Good afternoon, ladies and gentlemen. Ali, can I perhaps just ask that you change the settings so that everybody can, all the presenters can share their screens?
I don't know if I have admin permission.
You are the host, otherwise you can make me host, then I'll do it.
Give me a second.
Should work now.
Can see the screen.
Yes, we can see it.
Am I able to proceed?
I think let me just introduce you first.
Right.
Good afternoon, everyone. Welcome to the Friday afternoon session. So the two chairs for this session are me, Michael Kidd, and Ellie Petersen. And the way that we've decided to do it is that I'm going to introduce the speakers, and then Ellie's going to handle the question and answer session. So we're going to proceed on the basis that all three speakers will do their papers, and you can either ask questions in the chat or wait until the Q&A session later on to raise your questions verbally. So just note them down or put them in the chat. We'll deal with them all at the end. So our first speaker from the Endangered Wildlife Trust and Christo Reader's attorneys, Ashleigh Dore, is going to talk about ecologically sustainable use versus use that is sustainable, understanding the true ethos of Section 24B3. Over to you, Ashleigh.
Thank you very much, Chair. And thank you very much for the opportunity to engage on this topic of teasing out the differences between ecologically sustainable use that is sustainable, and broader sustainability principles in general. As introduced, my name is Ashleigh Dore. I'm from the Endangered Wildlife Trust, and this presentation is a joint initiative between the Endangered Wildlife Trust and Christo Reader's attorneys. The presentation will consider the existing legal and policy provisions that relate to sustainability and sustainable use in South Africa. And then what we're going to do is do a overview of principles within the international context that relate to sustainable use, and then consider how these can be applied and should be applied in relation to the inclusion of wild animals in the Animal Improvement Act. And then we'll conclude the presentation considering a new definition of sustainable use that was introduced in June of this year under the draft policy of conservation and ecological sustainable use of elephant, lion, leopard, and rhinoceros. There are elements in the beginning of this presentation which is similar to other works of the EWT within this field, but it is important to set a context or framework before we move into the specific application of sustainability and the AIA. So please do bear with me as I provide an overview. And also please bear with me as I flesh out the Constitution, which I'm sure we're all very familiar with. But it is an important starting point because of a narrative that exists quite prevalently within the wildlife space. And that is a narrative that there's a right to use, a constitutional right to use. And we hold that this is not a correct interpretation of Section 24. On our interpretation, what the Constitution provides for is the right to have the environment protected through measures that secure ecological sustainable use or ecologically sustainable use. There's no direct right in itself to the sustainable use of natural resources. And it's an important starting point because we're going to be discussing this narrative as the presentation continues. In teasing out the differences between sustainability and ecological or ecologically sustainability, what we would like to look at is the workings of or writings of Reuben and Robbie. When we look at sustainability itself, they hold that it recognizes the limits of resources, especially in light of human population growth, and promotes the use of resources in a way which would not compromise economic opportunities or social well-being. So very divorced from considering ecological provisions. When we look at ecological sustainability, they hold here that it requires, among other things, meeting national and international biodiversity obligations, as well as ensuring an acceptable state of health of resources in the short and the long term. And that difference between the short and the long term is quite interesting because it doesn't really come through in our biodiversity provisions, which we'll be discussing later. What I'd now like to spend some time on is discussing an evolution of the principle of sustainability, using writings around sustainable development as a framework. And reference here is made to the National Framework for Sustainable Development that was published in 2008. And interestingly enough, this framework was developed in recognition that South Africa did not have a common national vision or strategy for achieving sustainable development. And I would argue that that is exactly the case that we find ourselves in relation to sustainable use. We sit in a policy vacuum with a lot of different competing narratives about what sustainable use is, what ecological sustainable use is. So with that in mind, the framework for sustainable development introduced a new approach to sustainable development, and that's a systems approach. So moving away from the tiered approach, or what they frame as the weak approach to sustainability that's reflected on the left of the screen, to recognizing, and this is a direct statement from the framework, that we must acknowledge and emphasize that there are non-negotiable ecological thresholds that we need to maintain, and that we need to acknowledge, and that we must accept that social, economic, and ecosystem factors are embedded within each other and underpinned by systems of governance. So really reflecting a more integrated, holistic approach to balancing the different elements of sustainability in a way that recognizes the ecological provisions. Looking now at sustainability within, or sustainable use within our legal frameworks, I'm focusing specifically here on the National Environmental Management Biodiversity Act, or NEMBA. I do recognize that there's sustainable use provisions in our Marine Living Resources Act and our provincial legislation, but in the interest of time, I'm focusing it on our biodiversity legislation at the national level. What NEMBA provides is a definition of sustainable in relation to the use of biological resources, holding that it would be the use of a resource in a way and at a rate that would not lead to its long-term decline, would not lead to the disruption of the ecological integrity of the ecosystem in which it occurs, and would ensure its continued use to meet the needs and aspirations of present and future generations. There are a number of references across NEMBA in relation to ecological sustainable use, but the most relevant is probably chapter 4, where we can see the application of the concept to a degree, with a permit system that allows for the monitoring, presumably, of wild animals to ensure unsustainable practices do not occur. But we need to note a number of critical failings of NEMBA in relation to sustainable use. And the first is a lack of alignment with that systems approach to sustainability. What we have up on the screen in terms of this definition is a very, very narrow approach to sustainability, looking only at biological sustainability. There's also a lack within the provisions of NEMBA, read with its regulations, of any mandatory requirements for risk assessments, any mandatory requirements for environmental assessments, any mandatory requirements for the submission of management plans or biodiversity plans when permit applications are being submitted and considered. And then also the approach to sustainability here is negatively framed. Now, these failings must be considered serious flaws if NEMBA calls for the sustainable use of resources, but there's no requirement, legal requirement on applicants to show proof that there is elements of sustainable use. This is a failure, and something that needs to be addressed as I suppose our legal framework develops. And further, what we need to note here, and I've mentioned it earlier, is that we're operating in a policy vacuum as it relates to sustainable use. And we submit it's the basis of this policy vacuum that we have no provisions guiding sustainable use and what the narrative around sustainable use is that has allowed a narrative of use that is sustainable to grow. And here I'd like to rely on the writings of a sustainable use subject matter expert who confirmed, her name's Rose Cooney, that for use to be considered sustainable, it is not enough for the use or the used resource to be sustained. The use must not involve unsustainable impacts of the broader biodiversity ecosystem. What I'd like to consider now is moving into the international context. I'm not going to spend time considering sustainable use in terms of the Convention of Biological Diversity. I would like to focus the time in this presentation to principles established by the IUCN for ecological sustainability. And these principles were framed by the IUCN considering specifically trophy hunting, but I feel that they can be applied and should be applied more broadly. And the principle starts off with biological sustainability. Here, the IUCN holds that use can be biologically sustainable when it doesn't contribute to the long-term decline of a species, when it doesn't inadvertently facilitate threats to species, so that would be like poaching or illegal trade, and when it doesn't substantially manipulate ecosystems or component elements of those ecosystems. So biological sustainability by the IUCN is very much what is captured in our definition of sustainable use that has just been up on the screen in terms of NEMBA. So can we go further? And we would submit that we absolutely can. And this is guided by the remaining principles identified by the IUCN. And the second is a net conservation benefit. And here what the IUCN says, amongst others, is that use can have a net conservation benefit when it produces income, employment, and other benefits that generate incentives for the reduction of pressures on populations of target species. When we consider the next principle, this is one of socio-economic and cultural benefits. And here the IUCN says that use can and should, and in our view must, have socio-economic benefits. And this will be achieved where the use respects local cultural values and practices, where it's accepted by members of the local community from where it comes, and then from an economic perspective, where it promotes long-term economic sustainability. When the IUCN considered adaptive management as a principle for sustainable use, it says that this must be premised on appropriate resource assessments and risk assessments. And I already confirmed that NEMBA does not hold these to be mandatory requirements in applications. It must be based on laws, regulations, and quotas that are transparent and clear. And we'll show within the next case study how this is not achieved with the ARA matter. And then also it requires the production of reliable periodic documentation. And those of us in the biodiversity field know how challenging it is to have updated NDFs and BMPs. So there's definite room within our biodiversity framework to enhance adaptive management. And then finally, my apologies, it requires accountable and effective governance. And this requires clearly allocated management responsibilities, the elimination of corruption, and compliance and enforcement of national laws. And again, I don't think this is limited to those of us in the biodiversity field, but environmental field broadly. We know and understand the challenges relating to compliance and enforcement. So having set the scene very briefly and very quickly on the national framework as it relates to sustainability and sustainable use, and then also international principles that can, and in our view, should be applied to considerations of sustainable use. What we would now like to do is discuss sustainable use in relation to the decisions taken to list wild animals under the provisions of the Animal Improvement Act. The Department of Agriculture, Land Reform and Rural Development, now DALRA, previously the Department of Agriculture, Forest and Fisheries, in two separate points, in 2016 and in 2019, amended tables in the regulations to the Animal Improvement Act, or the ARA, which lists a large number of wild animals as landrace breeds. And by listing them as landrace breeds, they're included in the definition of animal for purposes of the Animal Improvement Act. Now, these animals include a wide range of threatened and protected species, or species that are listed as threatened and protected species, but also species that are listed as alien and invasive, and include a wide number of charismatic species, specifically our black and white rhino, lion, and cheetah. In January 2020, the EWT launched an application in the North Gauteng High Court, specifically to challenge and review this decision. So I'm not going to be going into the merits of the case broadly. What I'd like to focus on specifically is the link between these decisions and sustainable use. Now, the listing of wild animals under the AIA and corresponding actions and activities which the AIA enables, specifically selective breeding and the registration of breed societies, which would then have an exclusive monopoly on determining breed standards and registrations of breeds, even though we're dealing with species and not breeds. We hold that this is not in line with sustainability as provided for in NEMBA. And the basis of this is a 2018 report published by the Scientific Authority of South Africa, which made the following finding. Intensive management and selective breeding of game poses a number of significant risks to biodiversity at landscape, ecosystem, and species levels, and may compromise the current and future contribution of the wildlife industry and to biodiversity conservation. So off the definition, narrow as it is of sustainable use in NEMBA, this decision cannot be, the listing of wild animals under the AIA does not meet the definition of sustainable use. We also hold that it doesn't meet the provisions of Section 24 in that it does not align with the system's approach to sustainability and is not aligned with ecological sustainability. It focuses rather on the use of the species, the sustained use of the species, and not ecological sustainability. And when we considered it against the IUCN principles for sustainable use, we found that it fails to meet these principles as well. The intensive and selective breeding of wild animals will, in our view, and supported by our scientific authorities report, substantially alter processes of natural selection and ecosystem functioning. That the breed societies will not, in our view, produce income, employment, and other benefits that would generate a reduction in pressure. In actual fact, considering other industry practices that are comparable, it may actually exacerbate threats, specifically human-wildlife conflict. That the Animal Improvement Act listings provide for the creation of breed societies, creating closed markets, essentially, and doesn't promote justifiable socioeconomic benefits as your involvement in these societies is limited to those who are registered. That adaptive management will not be achieved in that there are no resource assessments or risk assessments included currently. That adaptive management is not currently achieved as the basis for the listings were not transparent. And that accountable and effective governance is not going to be achieved due to the confusion relating to mandates between DALRID and the Department of Forestry, Fisheries and the Environment. What we found, or as our submission at least, is that the listing of wild animals in the Animal Improvement Act is contrary to the provisions of sustainability as defined in NEMBA, is contrary to international principles on sustainable use, and is not in accordance with the Constitution of South Africa. Looking broadly now at sustainable use in general, what we've also found is that the current application of sustainable use is not in line with our Constitution or with the system's approach for sustainability as developed in policy. South Africa needs an approach to sustainable use that meets the constitutional requirements of protecting the environment, and that this needs to be implemented at legislative and policy levels as well as through case law. So is there a light at the end of the tunnel? And we would like to submit that there is. I'd mentioned earlier at the beginning of this presentation that there's a draft policy on conservation and ecological sustainable use of 5 species, white and black rhino, leopard, lion, and rhinoceros. The 2 rhino species, lion, leopard, and elephant. This was published for comment in June 2021. The comment period closed in July, but it has now been extended to the 14th of October. And it introduces a wider definition of sustainable use. So there's elements from the previous definition, and you'll see those reflected at parts A and B. And then the definition goes further, and it says that it's sustainable use in relation to the use of biological resource, means the use at a rate and a rate that does not compromise the ecological integrity or ecological resilience of the ecosystem, is humane and does not compromise well-being of any animal of a species of wild animal, so introducing welfare and well-being provisions. serves in or is not detrimental to the public interest. So looking at the broader South African community, considers the social, economic, and environmental impacts of activities collectively, including the disadvantages and benefits, so taking more of a systems approach, and then ensures the continued and future benefits that are fair, equitable, and meet the needs and aspirations of present and future generations. So that's quite aligned with the third provision of our existing definition.
Ashleigh, you have 5 minutes.
Thanks very much. I'm actually wrapping up. So we recognize that the definition of sustainable use is a valuable step forward in advancing South Africa's approach towards promoting wildlife utilization that is ecologically sustainable, and we support the definition. But we do recognize that should the definition reach beyond or be applied beyond the 5 species, that broader consultation and public participation processes may be required. And we would also caution that if there are additional possible future public participation processes, they shouldn't result in different definitions of sustainable use being applied in different contexts. So what South Africa really requires is a unified foundation for sustainable use that we can operate off. And with that, I thank you.
Thank you very much, Ashleigh, and thanks for sticking to the time. The next speaker, let me just repeat for those people who might have come in late that we're going to leave the questions and answers until after all 3 speakers have given their presentations. So our second speaker for this afternoon, who's talking on a topic that is a particular interest of mine, is Nsikan-Abasi Odong from the University of Ottawa in Canada. And the topic of her presentation is a critique of the right of access to water in South Africa, General Comment number 15 of 2002 of the Committee on Economic, Social and Cultural Rights as benchmark.
Thank you. I'd like to share my screen. Mr. Kidd, can I go ahead?
Please go ahead.
Yeah. So. Can you see?
I can see it, but it's not in the presentation mode. Do you want to just?
Oh. Do I?
Just click on it, yes. It should work.
Is it okay now?
It's still showing me.
Okay, let me see what to do. Okay.
We can see it. It's fine. If it doesn't work, you can carry on with that unless somebody's got a technical suggestion.
Okay.
You can also go to view.
Okay. Can you see? Can
There
you see
you
now?
go.
Yes, there we go.
Yes.
That's
All
fine.
right.
Thank you.
Thank you, and sorry for that mix-up. So my name is Nsikan-Abasi Odong. I'm a doctoral candidate at the University of Ottawa here in Canada. Thank you so much for inviting me to share my thoughts on this topic. I am very grateful. So this is the table of content. I'm going to introduce the topic and then look at the elements of right to water, which is that water has to be adequate, and then look at the state duties on the right of water, limitations on the realization of the right in South Africa, and then conclusion. So I'd like to start by saying that South Africa is the first country that has explicitly constitutionalized a right of access to water. While the General Comment number 15 is not a hard law, it is a soft instrument put in place by the United Nations, but experts have said that it is the most comprehensive instrument on the right of water. So I thought it would be a good benchmark to see the progress that South Africa has made. So talking about elements of water, according to according to general comment 15. Oh, sorry. Sorry, I don't know what I've done. Oh, sorry. Sorry, I moved too quickly. Yeah, so water has two elements. The right to water has two elements: sustainability and adequacy. And so when we're looking at sustainability, Article 11 of General Comment, number 15, looks at sustainability from two perspectives: sustainability in the now and sustainability for the future. According to the government of South Africa, the government is struggling to meet the water demands of the current generation. In fact, water coverage in 2015 was 77%. It increased slightly to 80% in 2017 and 86% in 2019. That's in the urban center. When you look at the rural communities in South Africa, as at 2017, it was 67%. So we can see that if you look at, if you use the benchmark stipulated by the general comment, South Africa is struggling to meet with sustainability in the present. And then when you're looking at sustainability, future sustainability, it doesn't look likely that South Africa is going to meet, the benchmark put in place by general comment number 15. For instance, already the water stress level in South Africa is over 41%, and the stress level affects freshwater sources. You also have issue of climate change. You also have, affecting, rainfall, because rainfall is a good source of water for agriculture. And then you look at population growth. The demand by water in 2020 is projected is projected at 17.7 billion cubic meter. And already the government is saying that to meet that projection, there's already a shortfall of 37% in terms of financial resources to meet that demand. And then when you're talking about adequacy of water, so adequacy of water has three conditions, according to Article 12 of the General Comment. Water has to be available, it has to be of high quality, and it has to be accessible. So let's see how South Africa is faring. In terms of availability, Regulation 3 of the regulations relating to compulsory national standard and measure for, water in South Africa prescribes 25 liters per person per day, whereas Article 12 speaks about water being available and adequate, for all its users across board. So we can see that when you measure it with this standard, South Africa is struggling. In terms of course, we can see the report by the Water Institute of South Africa. And so 56% of about 150 municipal, water works are already, dilapidated, and that affects the quality of water in South Africa. And so when you look at accessibility, we're looking at General Comment 15 talks about 4 types of accessibility. And so we'll look at it and see if how South Africa is faring. So in terms of physical accessibility. Water should be available within close proximity. But if we remember the record that we saw earlier, South Africa is struggling to provide water for, even those in the urban center and also those in the rural community. And so economic accessibility means water has to be affordable. But poverty in South Africa is relatively high, especially among the Blacks community, and is affecting people's ability to pay for water services. And if you remember, in 2000, because of the disconnection of water, because people couldn't afford it in KwaZulu-Natal province, it led to the worst outbreak of cholera in that province. And then when you're talking about non-discrimination, of course, South Africa is also struggling to meet to satisfy that benchmark. We saw statistics in the rural community. A lot of people don't have access to water, and even in Soweto, which is a predominantly Black community, the way the water services is built for is different from the way it is built for in Johannesburg, for instance. In Johannesburg, if you owe, you are allowed, certain procedural measures kicks in. Government won't disconnect you, immediately. But in Soweto, it's not like that. Once you have exhausted the free water that government gives, or you have exhausted your credit, you're automatically disconnected. And then in terms of information accessibility, well, in the case of Lingdingwe Mazubuko versus City of Johannesburg, I hope I got the pronunciation right. The Constitutional Court held that government has been, upfront in communicating effectively with, the water situation to South Africans. So, in the light of the decision of the Constitutional Court, I will say that South Africa has done fairly well in that regard. How about duties to state duties on the right of water? Well, general comment number 15, talks about 3 duties. But the South African Constitution, specifically Section 7, Sub 2, creates another additional duty. But I'm going to, since I'm using the general comment as the benchmark, I'm going to just discuss the 3 duties stipulated by that instrument. And so the first duty is duty to respect. And so this duty stipulates that the state, should not interfere either directly or indirectly with, the enjoyment of the right to water. But that's not the case in South Africa. In fact, in the Ngwathe local government municipality in the Free State, we had a lot of, we saw when government will deliberately pollute, the Vaal water source. Government will just pump effluent into that water source, and that affected the quality of water. And I think there were a few cases decided on that issue where the court held that government did not, fulfill the duty to respect in terms of right to water. And then we have a duty to protect. This duty, mandates, state parties to enact legislation that will, enable their citizens to enjoy the right to water. And then we have seen in South Africa, of course, they have enacted the regulations relating to compulsory national standards and measures to conserve water. So fairly, South Africa has done well in satisfying that duty. And then the next duty is duty to fulfill. And so Article 25 of General Comment insists that government has to, has to fulfill these rights. And so earlier on, I gave us the statistics. And so we can see that government is struggling to meet this duty. But comparatively, because I'm Nigerian. So if you compare South Africa with Nigeria, I will say that South Africa has done, very well in terms of this duty, because in Nigeria, I am not even sure that we have anything close to the level of provision of water services that South Africa has been able to provide for its citizens. So what are the limitations on the realization of the right of access to water in South Africa? So the first thing I'm going to say is that the language of Section 27 sub 1B of the Constitution, it creates some form of a legal challenge, because that section speaks about the right of access to water and not a right to water. My thinking is that access right is different from the right itself. And so when you look at access right, I think there is some form of limitation on the enforcement of rights. Of course, in the case that I just mentioned, this was one of the issues that the Constitutional Court had to decide upon. And the Constitutional Court said, well, the Constitution did not provide for right to water, but rather it provided for right of access. So we can see clearly the limitation in Section 21 sub 1. And then another limitation is that a right to water is considered a socioeconomic right. And when you're talking about socioeconomic right, you're looking at progressive realization of it. So what it means is government, government is not compelled, to provide that right immediately, but just making incremental progress. And that again was a point that the Constitutional Court amplified on in the case that I just mentioned. The Constitutional Court said, well, because it is the Constitution talks about progressive realization of socioeconomic rights, you can't insist on government to provide you right of water immediately. And then in terms of legislative limitations, we saw that that legislation specifies 25 liters of water per person. And so even though government has acknowledged that provision is inadequate, but government has not done anything to increase it. And then another thing will be lack of resources to invest in water infrastructure. We saw earlier on with the government, government is struggling to meet, to provide water for South Africans, and government did a 10-year plan actually from 2019, and then government said, look, the way it is, we have, shortfall in funding. I think 37%. So we see that lack of resources is affecting government ability to invest in water infrastructure.
You have 5 minutes left.
Thank you. And so what would be my recommendation? My recommendation would be that perhaps the language of the Constitution, the language around Section 27, South Africa might need to look into that language, because that language, talks about access right to water and not a right to water. And then government too needs to provide funding, to water services. I think that if these things are done, South Africa would be able, to come close to the stipulation of the general comments. Thank you for listening to me. I'm grateful. Thank you. Bye-bye.
Thank you very much. Nsikan-Abasi, sorry I called you she earlier. I saw the photograph on the Zoom profile and it was a woman. So but that's probably your wife.
That's my wife, sorry.
Yeah. And then our final speaker for this session Reuben Chifundo Nazombe from Arrupe Jesuit University. He's speaking on agricultural cooperatives in section 24B of the South African Constitution, a measure to secure ecologically sustainable development while promoting justifiable economic and social development among smallholder farmers in South Africa.
Thank you very much. I don't know if you can see the slides.
Yes, the screen's been shared. Thanks.
Right. Thank you all. First of all, thank you for this opportunity to present on an issue that is very close to my heart, this issue of smallholder agriculture cooperatives. The title is longish, Agriculture Cooperatives and Section 24B of the South African Constitution, a measure to secure ecologically sustainable development while promoting justifiable economic and social development among smallholder farmers in South Africa. So the outline of this presentation is that I'm going to introduce the presentation, and then I'm going to talk about the state obligation to sustainable development under Section 24B, and then cooperative societies and sustainable development. And then I'm going to look at the framework for developing smallholder farmers through developing cooperatives as a measure towards fulfilling the obligation under Section 24B. And then I'm going to conclude. So by way of introduction, Section 24 of the South African Constitution creates in a very clear language an obligation on the state to adopt reasonable legislative and other measures towards sustainable development in the implementation of the environmental right. Now, this presentation focuses on the obligation towards smallholder farmers. Why? Because they are very critical agents in the advancement of sustainable development goals, and by inference, sustainable development under Section 24B of the Constitution, because of their strong reliance on agriculture for their sustenance. The South African government identified agricultural cooperatives as critical in poverty reduction, unemployment, high levels of inequality, and as means towards accelerating empowerment of disadvantaged majority. The government developed a framework to develop smallholder farmers through development of cooperatives. I'm referring to a July 2012 document, which is the framework for the development of smallholder farmers through cooperatives. Now, the main argument in this presentation is that, though not clearly seen as such, by developing an elaborate framework for developing smallholder farmers through the development of various cooperatives, the government of South Africa adopted a reasonable measure towards sustainable development goal of Section 24B of the Constitution. Now, this presentation essentially analyzes the obligation of the state created by Section 24B in line with the relevant international instruments. The presentation views the development of smallholder farmers through cooperative development as a reasonable measure in fulfilling the obligation imposed by Section 24B for the reasons that will become clear. Now, what is the state obligation to sustainable development under Section 24B? The section itself states that everyone has the right to have the environment protected for the benefit of present and future generations through reasonable legislative and other measures that prevent pollution and ecological degradation, promote conservation, and secure ecologically sustainable development and the use of natural resources while promoting justifiable economic and social development. You will see that much of the discussion will focus on Section 24B3 of this section. Now, this section creates a more directive principle that imposes a positive duty on the state to promote the environment, to present for the present and future generations. And apparently, this section relies on the concept of sustainable development. Now, what is this sustainable development? This is a combination of two words, sustainable, sustainability, and development. Development is not a goal, but it's a means. It is a process, and so it cannot be sustainable in itself. While sustainability is the ability to maintain a desired condition over time without eroding natural, social, or financial resources. It is an ultimate goal which can be achieved through development. Therefore, the two terms cannot be separated. That report has defined sustainable development as development that meets the needs of the present without compromising the ability of future generations to meet their needs. So sustainable development has three dimensions, which we're going to look at shortly: environmental, social, and economic dimensions. Now, the environmental dimension refers to the resource base. This is the object of sustainability. Now, and the economic dimension refers to the maximization of net benefits of economic development subject to maintenance of services and quality of resources, while the social dimension refers to the sustainability of moral capital of a particular society. So sustainable development requires integration of these three dimensions: the social, economic, and environmental factors in planning, implementing, and evaluating decisions to ensure that development is sustainable. As it was stated in this fuel retailers case, that the Constitution recognizes the interrelationship between the environment and development. Indeed, it recognizes the need for social and economic development. It contemplates the integration of environmental protection and socio-economic development. It envisages that environmental considerations will be balanced with socio-economic considerations through the ideal of sustainable development. Now, what do we mean by reasonable legislative and other measures? There is that the test for reasonableness by Glasowski. So for that measure to be reasonable, it has to be comprehensive and coordinated. It has to be reasonable in conception and realization, balanced as well as flexible, refraining from exclusion of significant elements of the society, as well as responsive to the most urgent needs and the management of crisis. Now, the argument of this presentation is this: a reasonable measure is the one that includes and balances all the three dimensions of sustainable development. Such a measure balances environmental considerations with socio-economic considerations. Now, let's look at cooperative societies and sustainable development. The main argument under this section is cooperatives are a reasonable measure towards sustainable development under Section 24B because of their capacity to balance the tripartite dimensions of sustainable development. What are these cooperatives? They are autonomous associations of people united voluntarily to meet their common economic, social, and cultural needs and aspirations through jointly owned and democratically controlled enterprises. Their principles include voluntary and open membership, democratic member control, economic participation, autonomy and independence, education, training, information, cooperation with other cooperatives, as well as concern for the community. They have interesting values like self-help, responsibility, accountability, and members' beliefs in ethical values of honesty, openness, social responsibility, solidarity, and caring for others. Now, cooperatives have been actively promoted as important instruments to promote sustainable development. This is so because the values and principles of the enterprise respond to the pressing issues of economic development, environmental protection, and social equity in a globalized world. They satisfy the tripartite dimensions of sustainable development through meeting the economic progress of members while satisfying their socioeconomic interests and protecting the environment. How do they do this? The environmental protection dimension, they do it by ensuring that natural resources are not depleted. They help local people to find solutions to the environmental change by defining their poverty and user rights, managing natural resources, and diversifying their economic activities to embrace green economies. And the economic interest dimension, they do this by generating economies of scale, improving bargaining power and tackling rural poverty, as well as increasing incomes of small-scale farmers, expanding poor people's access to financial services, and providing a wide range of services such as healthcare, housing, and utilities. The social interest dimension, they can help with conflict resolution, peace building, social inclusion, and social cohesion, because they bring people together of different religious and ethnic groups, and they can build trust and solidarity, leading to greater social stability. Now, since cooperatives are able to respond to the daunting task of balancing the 3 dimensions of sustainable development, they are a reasonable measure to fulfill the obligation to protect the environment through sustainable development in section 24B. Now let's look at this framework for developing smallholders through developing cooperatives as a measure towards fulfilling the obligation to sustainability under section 24B. We're not going to look at the whole document in detail, but the main argument that I'm advancing in this presentation is through development of a framework to develop smallholder farmers through cooperative development, the South African government adopted a reasonable measure towards its obligation to protect the environment through sustainable development. Now, smallholders are very crucial to national food supplies and economies, and they have a large role to play in sustainable food systems of the future. They are drivers of many economies through their potential, though their potential is often not brought forward. Now, there is a need to focus on smallholders if sustainable development in section 24 is to be achieved. Why? Because despite their importance, they face serious constraints which make it difficult for them to respond to the tripartite demands of sustainable development. On the social interest side, they depend on powerful actors like landowners and traders, and this makes it very difficult for them to manage resources. And on the economic interest dimension, due to market failure, poor economies of scale, poor bargaining power, lack of access to financial markets, lack of access even to nearby markets, and the environmental interest direction, because of lack of knowledge on how to conserve the natural resources like soil and water, among other things. So on their own, therefore, these smallholder farmers are not sustainable. They need to work together to meet the sustainable development goals. And cooperatives offer an opportunity for such goals to be achieved. Smallholder cooperatives play a role in enhancing the livelihoods of rural communities. So by choosing to develop smallholders to mitigate the socioeconomic contrasts they faced, the government adopted a reasonable measure towards fulfilling the obligation created by section 24B of the Constitution. Why is it important to view these measures as an obligation? It is very important to view this as an obligation because this will give us a proper basis for evaluating the mechanism through the basic minimum set out in the obligation imposing legislation. For instance, when we look at the cooperatives developed towards the smallholder development in this framework, one will observe that they are only focusing on the social and economic interests, leaving out environmental interests. For instance, this framework includes input supply cooperatives. This is to counter supply of inputs constraints. It also has marketing cooperatives, which are to counter access to markets. It also has financial services cooperatives or cooperative banks to counter access to finance, as well as agro-processing cooperatives and value-adding cooperatives. What is conspicuously missing in the framework are, for instance, sustainable agriculture cooperatives and or environmental cooperatives. Sustainable agriculture cooperatives, they diversify activities, while environmental cooperatives help farmers to self-regulate and develop locally effective means for the realization of the environmental objectives in their farming activities. Now, if we view such mechanisms as obligations, it gives us tools to critically assess these measures for any gaps in order to make them complete. In conclusion, looking at the nature in which cooperative societies bring together the three dimensions of sustainable development, it is the argument of this presentation that cooperativism will move from being a mere concept to a paradigm of sustainable development. Thank you all. That's where I stop my presentation.
Thank you so much to all the speakers. We have some questions in the chat. We'll start with Ashleigh. Melandri asked, oh, by the way, Wilhelmine posted the extension notice that you mentioned in the chat. So if people are interested in that, that would be awesome to have a look at. So Melandri asked, thank you for an insightful presentation, or she says, and then she says, well, this question doesn't directly relate to your discussion. She's wondering where community-based conversation efforts fit into the framework of your discussion. And she believes that Namibia has seen relative success in local wildlife conservation efforts. And are there similar methods or measures in South Africa?
Thanks. Thanks, Melandri. Excellent question. I think there are linkages, but perhaps to first address your query around community-based conservation efforts in South Africa. I am aware of several, but it was a specific finding of the recent high-level panel that was instituted to consider legislation, policy, and practices relating to the two rhino species, elephant, leopard, and lion. One of the findings, or a number of the findings of that panel, related to the increased need of inclusive community practices in South Africa. And there's a number of goals and recommendations that speak specifically to enhancing this field. So it's going to be a very exciting space, hopefully within the next couple of years in South Africa, while we grow and develop this. And Namibia definitely offers excellent case studies or bases of which to consider. In terms of linking the discussions around ecological sustainable use and community-based conservation efforts, I think they're mutually supportive. And this is, as practices are growing and industries and sectors are expanding, this is why we need a solid policy foundation for sustainable use supported by legislative provisions. So I hope that addresses your question, and thank you very much for it.
And then Peter had a question for you as well, Ashleigh. He said, thank you for the presentation. And then he said, regarding the need for a single definition, do you anticipate a distinction between biological resource in the new definition and natural resource in section 24B3, which could also refer to mineral resources, in which case the definition might not fit?
Thank you very much for that question as well, Peter. Just to clarify, and apologies if it didn't come through clearly in the presentation, I was referring to one definition in relation to biological resources, but your question has actually posed whether we should limit it there. And if we're looking at ecological sustainable use, we should be looking at ecological sustainable use of natural resources, not limiting it to biological resources. And considering even just the definition of biological resource, it includes microorganisms, it includes plants, and there will be adaptations specifically around the well-being provisions and the welfare provisions as it relates to those, which then applies quite equally to mineral resources. So I hadn't anticipated or it wasn't my intention for one definition, but off the basis of your question, I actually think that South Africa should challenge itself, and this is the approach that we should be taking, is to have one definition that is then adapted, obviously, to the resource in question.
And then we have a question, sorry, I forgot to put on my camera. We have a question from Michael who'd like to ask it to Nsikan-Abasi. Would you like to go ahead, Michael?
Yes, thanks. Nsikan-Abasi, I was interested in your presentation because, as I said earlier, it's something that I'm very interested in myself. I was a bit perhaps bewildered by your comment that the right to water is perhaps wider than the right of access to water. As I understood you, the right of access to water you suggested was a limitation of the right to water. Is it perhaps not better to think of it as maybe not so much a limitation, but that the right of access to water is basically putting a duty on the state to actually do something in relation to ensuring that people have water? The way that I would understand it is that if you have the right to water, all that would ensure is that the state does not do anything to prevent people accessing water. So in other words, the state could say, there's the water, nobody owns it, nobody has exclusive rights to it, take as much as you want. Whereas the rights of access to water is actually putting a duty on the state to provide water for those people who are not able readily to get it. So, I mean, if you imagine somebody living 10 kilometers away from a stream, so you have the right to water, you can go there with your bucket and take water home. But the right of access to water requires some reticulation where you get the water from the source to the actual person. So I would argue certainly that the right of access to water is something more beneficial for the citizen than the right to water.
Thank you, Mr. Kidd, for that contribution. I don't take it as a question, I take it as a contribution. I think that it's a matter for interpretation, because my view is that when you're talking about accessibility, you're talking about a route to something. You're not talking about that right per se. So my understanding is when the Constitution provides for access to water, it's just providing a route to water and not providing that right. So that's my own understanding. But again, as I said, it's a matter of interpretation. But the point is whatever. I mean, if the precision in the wording of the Constitution will pressurize the government in providing water to the people, which is actually what the people need, then I'll be satisfied. I don't know if I've answered your question.
No, that's great. It was kind of a comment for you to comment on. So
yeah.
Gem ready to say she agrees, and thank you, Michael and Onyeme. Interesting perspective, and she says she also thinks that access to water is perhaps more focused than just a water right. I have a hand from Nazir. Would you like to go ahead? Have you unmuted, Nazir?
I'm so sorry. I've got a question for Reuben. I wanted to know from Reuben, thank you for the presentation, but what has been the practical experience of smallholder cooperatives since 2012? Has the smallholders expanded the law with regard to cooperatives? And if so, in which way? It's perhaps an unfair question, but I would want to, it's interesting nonetheless. Thank you.
Thank you very much for that question. I think that aspect, I think, is one maybe that requires further research. But what I was looking at is at the theoretical level. You are looking at a measure that fits the 3 dimensions of sustainable development that section 24B of the Constitution requires. I think in my research, I did not go further into that direction to see really what the cooperatives have really done in terms of attaining those goals. And I think that's a call for further research on that same point. Thank you very much. So I cannot say what progress has been done so far in the or even in the implementation of the framework itself. But I was just looking at this framework, the way it's structured and the goals that it wants to achieve, and looking at the Section 24B of the Constitution and trying to make that link to say, let's connect these two things. This framework is operating on its own. Section 24B seems also to be, but trying to look at this framework as an obligation. And after doing that, then I think we can try to see, take it further. Thank you. Sorry, I don't think I've answered your question correct. Thank you.
He says thank you, so I'm sure you did answer the question. And then just sticking with you, Reuben, I think Karen addressed this statement to you. She says reasonable measures are also those measures that can be regarded as scientifically defensible based on variable evidence, including evidence from demographics, economy, and the natural sciences. Would you like to comment on that? Reuben?
Yes. I think as I looking at the issue of reasonable measures, I think it's not a fixed way. It's not like a dogmatic way to say this is the way, from my perspective, to say a reasonable measure should be the one that fits all these dimensions. I think there are also other angles that the same reasonable measures can be interpreted. And I think I agree with that perspective, depending on the context which it's trying to respond to. But I was looking at it from this perspective, where you want to balance the tripartite dimensions of sustainable development, and then how the same is being implemented in a measure that is to include people. So I think reasonable measures, yes, they can be regarded as scientifically defensible, but I would still add the point that they should be something that meet those three objectives that Section 24B requires. They should be promoting economic, social, as well as environmental protection at the same time. No aspect should be sacrificed over the other. I think whatever measure, for it to be reasonable, I think in my understanding, it has to embrace those three dimensions together. So yeah, I will accept that. And I think as long as they stick to that tripartite dimension of sustainable development, which I just talked about. Thank you.
And then I am going to abuse my power as chair, one of the chairs, and ask Nsikan-Abasi one of my questions that I had. You spoke of water infrastructure, and I just was wondering if you've considered how climate change has become a reality and affects, the natural water cycle. And I know we saw evidence of this when Cape Town experienced its severe water shortages and the so-called day zero. So I wondered if you have considered what government can do to make water more accessible. I think we spoke about accessibility quite a lot. So how can government make water more accessible to people? I suppose you can use examples from Nigeria or South Africa.
Thank you for that question. I mean, the issue of climate change, it's been debated, and we see the effect of it. It affects all our sectors of economy, not just water. So while I would recommend that countries should key into all the thinking that has gone in the international community in terms of dealing with climate change. Specifically, I would recommend that South Africa continue to invest in its water infrastructure. We saw in my presentation, government actually drew a 10-year plan from 2019, to provide, water for all South Africans. But at the moment, government is complaining about a shortfall in finances. They're saying that I think they have a shortfall to the tune of 37%. So my thinking is, if government actually puts that money, put down that money and invest in water infrastructure, irrespective of the challenges that we might government might face as a result of climate change, government will at least be able to go forward in terms of providing water for South Africans. Thank you.
Thank you for that. Yeah. And then we have a follow-up question for Ashleigh. So Melandri says, obviously, thanks for the response. And she has another question for you. In her understanding, preventing ecological degradation and securing ecological sustainable development, as phrased in section 24, differs quite vastly from what ensuring ecological integrity refers to. What are your thoughts on this? And do you think cases related to the NEMPA and NEMBA often neglect reflecting on this aspect of the acts?
So I hope I've understood the question correctly, Melandri, and if I haven't, please just let me know. But I actually would regard looking at ecological degradation and then elements requiring ecological integrity and ecological resistance as being interchangeable or one and the same. So we would prevent ecological degradation by ensuring ecological integrity, if that makes sense. It's sides of the same coin. Though you raise an interesting point, and I do want to look at this in more detail, but that would be what my initial thought would be in relation to that. And then, yes, the short answer to whether NEMPA and NEMBA take ecological degradation into account sufficiently, I think that there's definite room for improvement, and this is why the new definition that was proposed in the draft policy is so exciting, because we're starting to add in those elements and considering broader ecosystem services, and looking at things a little bit more holistically. I hope I've understood the basis of the question, but that would be my response to it for now.
Well, even if you haven't, Tracy Linfield completely agrees with you.
Right. Thanks for that validation, Tracy.
Yes. Peter, you had a comment for Ashleigh. Would you like to kind of speak to it, or would you like me to read it out?
Either way. I'll say it. So there's a bit of glary in here. I liked your answer, Ashleigh. I think it's a challenge we can set for ourselves. And then it just occurred to me that section 2 of NEMA actually then refers to the renewable and non-renewable, which is a little bit broader, perhaps than biological, or is it? Is biological and renewable the same? Thanks.
It's an interesting question. So I saw the distinction in the comment that was raised, and I do still think, if we're looking at a definition, to have a uniform approach to ecological sustainable use, and how we tease that out in relation to the different resources should come through in the policies itself or the application of the legislation itself. But there are obviously differences between the different resources, and there's different requirements that need to be taken into account. I also wanted to note that while the draft policy is in relation to the 5 species, at least from its title, there was a requirement or call from the high-level panel for South Africa to actually draft a full conservation and biodiversity policy, so that we address this lack of a policy framework. And I think there's a lot of meat to kind of go through in fleshing out the different approaches, and whether we have one definition with different elements in it, or one unified definition, and the application of that definition comes through in the policies itself. That would need to come out in the process, I would say. But my gut feel is that we have one unified approach to natural resources, which would include biodiversity or biological resources, and renewable and non-renewable resources, and then take the unique characteristics of those into account in the application of the definition.
Thank you, Ashleigh. And then we have another question for Nsikan-Abasi from Karen. She said, would you regard the allowance of 25 litres per person per day as adequate access?
Thank you for that question. In the course of my presentation, I did compare that provision with what general comment specifies, and I felt that it was inadequate. Whereas general comment says water should be adequate, for personal use, but I think that 25 liters is not adequate, because when you factor all the things that you need to do, it's not. And even the government of South Africa had acknowledged that it wasn't adequate. But up till now, government hasn't done anything to, to step up, So in answer to that question, is not adequate. Thank you.
Thank you. And then we have a question from Nazir again. It's not a layperson question. I think it's a lovely question, Nazir. So farmers, I think this is to Reuben. Farmers use 70% of our water. Can the law be used to compel farmers care for community and environment to switch to regenerative farming practices that will result in massive water saving? Would you like to speak to that, Reuben?
Yes, thank you. Thank you very much.
I think it's unfair to put that on Reuben alone. I think I just put out generally to all the lawyers here.
That's fair.
Yeah, I think the whole idea, I think the language that we are using to say compel farmers is like, I think that's not the spirit of the section. The section is imposing positive duties. How do we make farmers use or sustainable use of water by farmers? I think it might be through adoption of technologies that help them to use, and how do they do that? Do they have the capacity to do that on their own, or what sort of help do they need? For instance, that's why I was looking at smallholder farmers and cooperatives. For instance, if you're looking at a farmer that is doing farming alone, and is facing serious constraints, doesn't have enough capital, doesn't have enough resources to do that, obviously is going to engage in unsustainable practices. But if, for instance, these farmers are put together and they bring their resources together, and through their resources together, they get extension services, they get access, for instance, to financial markets, and they are able to get, for instance, technologies that help them to save and manage water. I think we should move more towards finding ways as a part of obligation, not to say, oh, farmers, stop using, you are using too much water, but how do we make them have the capacity to be able to use the water? I think that's what the language of Section 24 is doing, is putting on the state a positive duty to find a way in which, for instance, it can make smallholder farmers or farmers in general that are using a lot of water, how can they use the water sustainable? And as I'm just explaining, maybe cooperatives can come in there helping farmers to get these technologies together, which on their own they cannot access. But if they pull their resources together in a cooperative, they can be able to access such kind of technologies. I think that's what I can say. I don't know if it is helpful.
Definitely. And while I have you here, Reuben, I've got a question for you. So you mentioned that by choosing to develop smallholders to mitigate socioeconomic constraints that they face, the state adopted a reasonable measure towards filling the obligation created by Section 24. I think that was from your slide. So can you expand on this reasonable measure, and what is it, and is it effective in your opinion?
Thank you for that. I was looking at this, the section, what it is required, the obligation, and sustainable development, what it means. That is a development that should satisfy the 3 dimensions of sustainability, for instance. So a measure that is adopted should be able to satisfy those 3 dimensions: the dimension of social interests, the dimension of economic interest, and the dimension of environmental protection. So then I moved on to cooperatives to say that cooperatives in general, they have been seen as vehicles and tools that can be used to, they meet those three dimensions: environmental protection through encouraging their users to adopt sustainable ways of using the environment, and they help them not to be sustainable by looking at other means. For instance, if you have a farmer that is getting enough from his small piece of land, there is no pressure for that farmer to open another farm somewhere or to exploit other resources somewhere. So you're looking at these three in one. So when you take care of the economic dimension of the farmer, he's able to sell he or she is able to sell the products and is able to get good money from the products. There's no pressure on that farmer to, for instance, exploit more resources. So the ones that it will make the farmer to be content with that. And then socially, they help the farmers to be their issues of bringing people together, social cohesion. So I was looking at that aspect of cooperatives and the demands of Section 24B of the Constitution. And then I was looking at that framework that the government adopted in 2012. It's a July 2012 document, a framework developing smallholder farmers through cooperative development. So I was looking at that to say, this measure, when you look at it, it's a reasonable measure to meet the demands under Section 24B of the Constitution. So I was saying, why should we look at this framework as a state obligation? Because now, when we look at it as a state obligation, we have it gives us the tools to evaluate as well as to assess the measure itself, how it is implemented. And if you saw the slides when I was saying, you will see that, yes, it's a reasonable framework, but you see that it has got a gap. The cooperatives that are being promoted in that framework, they are only focusing on the social and economic dimension. While I say that there are no cooperatives that are focusing on the sustainability or sustainable agriculture as well as environmental protection. So now we have the skills when we look at it from the environmental right perspective. We're able to see, no, this looks so rosy and nice. Yes, it's a reasonable measure, but there's this aspect that you did not, that was overlooked. So there's that I see that as a reasonable measure, though it is not fully complete. There's that aspect that it needs to be looked into, so that at least the cooperatives that are being promoted, they should be the ones that are able to satisfy the tripartite dimension. They should help the farmers to practice their agriculture, which is sustainable, ecologically sustainable, as well as improve their economic well-being, as well as their social well-being. So I think that's what I can say. I don't know if it does justice to your question.
It really does. It really does. And then Wilhelmine put up something just to strengthen what you were saying from yesterday's discussion. It's called Climate Resilience Through the Right to Food. So if you guys are interested, there's a link in the chat. Are there any other questions that we have for our speakers? It doesn't seem like it. Oh, Nazir, go for it.
I'm just going to rock the space a little bit with another lay question. So a lot of farming practice has moved more towards traditional farming practice, which is based more on today's regenerative farming thinking and practice. How does that, how is it covered by the law? So we know you've explained how sustainable development is based on the tripartite elements. how does regenerative farming or regenerative practice fit in there? Or has the law moved in that direction at all? Thanks.
Reuben, do you want to go for it?
Yes. I think it's very important actually to focus on agriculture, because much of what we eat comes from agriculture. And as I pointed out, smallholders play a very big role in this kind of perspective. But now, should we just focus on, for instance, the economic side of farming? If we just focus on the economic output of agriculture, for instance, we are going to do that at the expense of the other dimensions. The environment is going to suffer, and maybe the social dimension might also suffer. So I think what the sustainable development requires us to do is, whenever we are thinking about something, for instance, even when we are doing farming like agriculture, we have to look at those three interests in one. So we just don't farm to get the money out of the environment, but we should also maintain the integrity of the environment through our farming, and at the same time, the social cohesion through the same act. So, what the Constitution now requires, it puts a positive duty on the states to ensure. Now, that's why I focused on the smallholder farmers, to say that it should ensure that their agriculture is sustainable because of their strategic position for sustainable food production in the world. So the government should focus on that direction to make sure that agriculture is sustainable. And for smallholders, they face so many constraints. Market failure, poor economies of scale, lack of bargaining power at the market because of their social standing. So if they can produce their goods, but if they produce their goods and they take care of the environment, but they go to the market and they don't get enough from their products, that's why I'm saying this is not sustainable. If they're farming year in and year out and their livelihood is not improving, then their agriculture is not that is not sustainable. So the state should implement positive, reasonable measures, legislative and other measures. So I was looking at cooperatives as one of that measure, which can be very much looked at as fulfilling that obligation of the state to ensure that agriculture, in particular for smallholder farmers, responds to the tripartite demands of the sustainable development under Section 24. Thank you.
Thank you, Reuben. And then we have one last question from Karen before we wrap up the session. Go for it.
Thank you very much. I just wanted to add on the discussion of on agriculture. It's often, we have a perception of what is agriculture and what is a farmer, and we see a farmer in a two-tone shirt with a dog in his bucky. But that's not actually how it is. We see more and more agribusiness and agricultural organizations, large-scale companies who have got a number of large-scale farms, and nobody is more water conscious than the farming community people that I have encountered. And in fact, of one of my agribusiness clients actually asked me to help them to do what they call water footprint determination, and how they can reduce their water footprint. In other words, to use, for example, less water to wash their gooseberries or whatever their produce are, not because of legislation, but because they are export farmers and they are measured with European quality and environmental standards. So the driving force is an economic one and not necessarily a legislative one. There are detrimental impacts to things like monoculture. But I think if there's one group of people who understand the value of water more than anybody else, it is the farmers, the individual farmers, and the large-scale commercial ones who are actively looking at ways to save water and reduce and reuse water. if we want to look at water saving, we need to look at plumbing, because just the loss from the Vaal Dam alone through plumbing leaks is more than half its capacity. And so that was the first point I want to make. And the second point I want to make is Water Affairs has missed an opportunity to grant access to water to historically marginalized up and coming small scale farmers through the general authorizations. And they really should have used the general authorizations as a tool to facilitate more access to up and coming small scale farmers as the ones that Reuben was referring to. And those were the 2 points I would have liked to add.
Thank you so much. In the last minute, I just want to use my power as one of the chairs just for a shameless plug. If you're not a member, please visit our website, elasa.co.za, and look at the membership benefits and consider signing up. And then if you think this conversation is worth sharing, the video will be placed on the ELA YouTube channel, so you can share it there. And finally, connect with us on all our social media under the name Environmental Law Association South Africa. And all that's left for me to do is to thank you all, especially our presenters, for their presentations. And thank you for the very lively discussion that we've just had. And thank you to my fellow chair for helping me and helping us through this session. So may your Wi-Fi be strong, may your family be well, may the odds be ever in your favor. Enjoy the rest of your day, everyone.
Thanks. Bye, everybody.
Bye, everyone.
Bye-bye, everyone.